what's up everybody? I'm John Miller, and this is How the Hell Did We Get Here? A U.S. history podcast. In the last episode, I talked about how the Jefferson administration, with congressional assent, though without an official declaration, went to war against the Marbury pirates in North Africa after years of these states sponsoring acts of thievery and kidnapping against American shipping and sailors. I also discussed the circumstances behind and the completion of the Louisiana Purchase in 1803, and I talked about how it fit into Jefferson's vision of the country, as well as how he created and launched the Corps of Discovery, led by Lewis and Clark, to explore and report about the interior of North America. I tied both of these developments to Jefferson's embrace of executive authority, now that he had a chance to wield it himself, and how the president's use of this power demonstrated the willingness of great men, quote unquote, in history to be flexible in their principles when it suits their purposes. In this episode, I will focus on the establishment of the federal judiciary as a co-equal branch of government. I will give a brief history of the judicial branch in the colonial period and in the time between the Revolution and the Constitutional Convention. I will explain the evolution of the judiciary over the course of the 1790s and the differing perspectives about what the proper role of this branch was, according to Republicans on the one hand and Federalists on the other hand. Finally, I will discuss the monumental importance of both John Marshall generally and his opinion in the Marbury versus Madison case in particular for establishing what has ever since been considered to be the primary purpose of the federal courts, judicial review. But before I do all that, I'd like to ask y'all to please like and subscribe if you have not already done so. It is the best way that you can help me to keep doing this if you're enjoying what I'm doing. Like, subscribe, tell your friends, tell your family, pass the word along about the show. The more followers I get, the more subscribers I get, the more views I get and all that stuff, the more likely it is I can keep putting this together. So if you guys are enjoying what I'm doing, please keep liking and subscribing and spreading the word. Thanks very much. As usual, I will get into the resources I used to put this episode together, and I will give you a question to think about as I go through all the information. I think you'll get a better understanding of what I'm covering. Beginning with the resources, which actually have changed a little bit this time around, and that's mostly because John Adams, the biography by David McCullough that I've been using, and The Art of Power, the Thomas Jefferson biography by John Meacham, I've been using for other episodes. They didn't say much, either of those books, about Marbury versus Madison or about the judicial branch in general. And that's something that I really wanted to cover because the judicial branch being able to establish itself as a co-equal branch of government in this period is really important. It is one of the most important stories of the very early 1800s, and I wanted to make sure that I covered it, and those books really didn't have a lot to say about it. So I'm not really using those books as references given that. Instead, I'm going to use a different book, one that I read specifically for this episode, that covers, as the title indicates, the Marbury versus Madison decision and the Marshall Court in a little more of a general way. And that book is The Great Decision: Jefferson, Adams, Marshall, and the Battle for the Supreme Court by Cliff Sloan and David McKean. I read that book specifically for this episode because it covers the Marbury-Madison case and the Marshall Court, which is what I'm talking about in large part for this episode. I'm also continuing to reference The American Pageant, the common AP US history textbook, as well as Give Me Liberty, another common AP US history textbook, and of course, Empire of Liberty, the book in the Oxford History of the United States series that covers 1789 to 1815. That book had a lot to say about Marbury-Madison, about the courts, but yeah, the other books, not so much. The question that I think would be good for y'all to think about as I'm going through this stuff is as follows. Why was the judicial branch of the federal government in such a weak position relative to the legislative and executive branches in the very early 1800s, and what did John Marshall and his opinion in the Marbury versus Madison case do to substantially strengthen the judiciary. I'll say that one more time. Why was the judicial branch of the federal government in such a weak position relative to the legislative and executive branches in the very early 1800s? And what did John Marshall and his opinion in the Marbury versus Madison case do to substantially strengthen the judiciary? So that's something to think about while I'm going through this stuff. And I think it's helpful to point your focus in a particular direction when you're talking about decades of information and a lot of, I think, fairly complicated ideas. Okay, on to the real substance of the episode, starting with a brief history of pre-constitutional jurisprudence, the fancy word for how judges think and interpret the law, how lawyers in general do it, really. The colonists' experiences with judges and the judiciary in the 17th and 18th centuries left Americans with a very sour taste in their mouths when it came to that branch of the government. Most in the colonies weren't all that fond of lawyers in general either, if what I've read is to be believed, and it seems plausible to me. Two factors generally contributed to this distaste for judges among the colonists. Number one, colonial judges often operated as extensions or appendages of either the crown or colonial governors and used their power to enforce the prerogatives of those figures. In that manner, they were more like pieces of the executive branch, and to the colonists, they seemed oppressive in the ways that the executive branch, whether you're talking about the monarchy or the colonial governors, could seem. Number two, the legal code, such as it was in Britain in the 17th and 18th centuries, was a Byzantine hodgepodge of often arcane common law. It seemed oftentimes arbitrary and capricious to those who stood before the bench, who were subject to the law's interpretations by magistrates and judges. It was difficult for your average shoemaker or farmer or blacksmith or whatever to make heads or tails of this common law, as it was referred to in Britain and in the British colonies. Literacy was not super prevalent amongst a lot of common British people, so certainly knowing common law, legal statutes, was not something that a lot of folks were very familiar with. And when they were faced with these laws, when they had to encounter them before experts in their mind, remember there's kind of a general hostility and disrespect for expertise amongst a lot of these common people in the 1800s, they saw it as just a whole bunch of bullshit, honestly. People making stuff up as they went, who presented themselves as part of the upper or better classes and could tell these poorer, less literate people what to do in a way that they had a difficult time fighting against. So when you look at it from that point of view, you can sort of see why it was that so many people had a fairly low opinion of judges, magistrates, and lawyers more broadly. In the 18th century, in no small part because of the influence of the Enlightenment, there was a push in many parts of Central and Western Europe to codify and make the law more specific. This was especially true in Prussia, other parts of what are now Germany, Austria, and France, but it did have some effect on Britain, the UK, England as well. When the revolution, the American Revolution, began, the hated magistrates and judges were an easy target for the ire of the colonists, who understandably associated these magistrates and judges with what they saw as the autocratic monarchy and colonial governors. Their robes, their ceremonies, their elevated benches, and all of that kind of thing just made it that much easier to tie the judges and magistrates to undemocratic authority. Additionally, many of the loyalists, and remember the loyalists are the folks in the colonies and the 13 colonies who sided with Britain, who did not want to break away, who saw themselves as Englishmen, not as something different. And it was a pretty significant portion of the colonists overall. Estimates are anywhere between like a third and like 25% of the colonists during the Revolution were loyalists, considered themselves to be loyalists. Many of these loyalists were lawyers, and the legal profession in general was tainted with this association with loyalists. There are estimates that as much as 25% of the lawyers in the colonies were loyalists who fled as the war progressed. A lot of loyalists took off for Canada, British, Caribbean, whatever, and a lot of these folks were lawyers, as it turned out. The rage, or the fad, if you want to call it that, of democratic reforms that took over so many of the state legislatures from 1776 through the 1780s extended to the judiciary, where judges often only served for a year and then left the bench as another judge was elected, which many judges were. They were not appointed any longer. They were elected in keeping with the democratic spirit of the newly independent United States, or the United States as it was breaking away. However, the democratic excesses of the 1770s, 1780s that frightened so many people, like the representatives who ended up going to the Constitutional Convention in Philadelphia in 1787, they saw all of this change to the law as its own form of chaos. And as laws were passed all over the place, left and right it seemed, they were passed so quickly and haphazardly that lawyers and judges struggled to even know what was legally acceptable or unacceptable from month to month. Sometimes even like week to week, they didn't know what the law was because it was changing so quickly in these legislatures that had become so much more democratic. Remember, they'd become a lot larger too. There were a lot more members of the legislatures than had been the case during the colonial days. And a lot more of these folks were from the middling sorts, or middling classes, if you want to use the parlance of the folks who looked at this and saw something distressful. This chaos, all of these new laws being passed so quickly, and democracy taking over and becoming this unwieldy beast in the eyes of a lot of folks, presented opportunities for unscrupulous men and ultimately caused so much disorder that Americans began to accept the necessity of lawyers, judges, and the co-equality of a judicial branch as described by Baron de Montesquieu. Now, I should remind everybody that under the Articles of Confederation, there was no national judiciary. And that is kind of demonstrative of the degree to which people in the states distrusted judges and the court system and lawyers. They didn't want a national judiciary. On top of the fact that in their view, it wasn't democratic. Judges were not democratic. They were often appointed, and they just made these pronouncements rather than being elected. Generally, this whole environment of a whole lot of democracy in the 1780s in a newly independent United States wasn't really conducive to the rule of law as a lot of people saw it. And that was a problem, so much so that even a lot of common people began to see the problems with not having a well-established system of laws and a system of courts in which they could present their legal grievances, whatever they might be, and have someone who knew the law tell them what was supposed to happen and have it be administered in a fair way. After decades and decades of dealing with judges and figures, magistrates and so forth that acted sort of dictatorially, that made most Americans, or many Americans anyway, have a negative view of lawyers, again, generally, and judges in particular. But after all the legal disorder of the 1780s, a lot of people started to recognize, yeah, actually, I think we do need something like a more structured legal system. So Americans decided that they wanted educated experts who could interpret and explain logical, limited laws that would make sense, quote unquote, to anyone not necessarily versed in the details of the legal code. They didn't want what was in operation in the colonial days, this weird, complicated, unwritten common law that judges just sort of allegedly knew. They wanted a legal code and they wanted a legal system, but they wanted it to be relatively simple and written down so everybody could read it, and not some kind of like secret code that only a few elites knew and could interpret. Thus, The men who met together at the Constitutional Convention understood the need for a judicial branch, where the Articles of Confederation did not have one, that would solve these uniquely American problems and work within a society that had a history of mistrust and suspicion when it came to the authority of lawyers in general and of judges in particular. So, what did that judiciary look like? It's not something I've talked a lot about, but it is something I want to get into right now. The Constitutional Convention left the judiciary as the least specifically described and least carefully constructed of the three branches of the government. Reading the Constitution, it is very apparent how much shorter Article 3, which is the article that lays out the judicial branch, is than Articles 1 and 2 are. Articles 1 and 2 being those that describe the structure of Article 1 is the legislative branch, Congress, and Article 2 is the executive branch, the presidency. For some perspective, Article 1 is 2,268 words. Okay? So, fairly lengthy. Article 2 is 1,023 words. A lot shorter than Article 1. Article 1 is a lot longer because both it lays out the functions of the legislative branch and a lot of other more general functions of the federal government. It kind of does both. But it's also demonstrative of the fact that those at the Constitutional Convention wanted to make the legislature clearly the most important of the three branches. Article 1, 2,268 words. Article 2, 1,023 words. Article 3, 377 words. That's it. It is literally 1/6 of the length of Article 1 of the Constitution. And that, I think, demonstrates, as well as anything, just how much more important Article 1, the legislature, was to those at the Constitutional Convention, and how much that the judiciary was going to be sort of the runt of the litter in terms of the three branches of government, at least at that point. The Constitution just says that there will be a Supreme Court and, quote, such inferior courts as the Congress may from time to time ordain and establish, unquote, that the judges will serve during, quote unquote, good behavior, which basically means they would serve for life. Good behavior, the limitation there is that if they did something fucked up, they would be impeached, removed in some way, but they wouldn't have to run for re-election or anything. Okay, and they would be appointed by the executive branch and approved by the Senate. And it finally says that the federal judiciary will have jurisdiction in a variety of instances, including cases under federal law, those pertaining to ambassadors and issues at sea, disputes between states, and a couple of other instances. But that is actually very important for the Marbury versus Madison decision, is specifically the jurisdiction that is given to the Supreme Court in Article 3. I'll get to that later on. Given how very little the Constitution had to say about the specifics of the judiciary, Congress got to work structuring it immediately as soon as it met, when the Constitution had been ratified, with the Judiciary Act of 1789. As with most issues, there was a push and pull between enthusiastic Federalists like Alexander Hamilton, who wanted a very strong judiciary with many districts that cut through states and lots of judges to actively advocate the supremacy of federal law, and on the other hand, anti-federalists, those that were not as enthusiastic about the Constitution or maybe out and out opposed it, who feared an active federal judiciary that would invalidate state laws and perhaps even tried to outlaw something like slavery. That was definitely a big fear among a lot of the anti-federalist, more wary of a stronger federal government crowd. As it turned out, the Judiciary Act of 1789 charted a middle path between the strong federalist version and the anti-federalist version. It created 13 district courts, one for each state, with the exception of Virginia and Kentucky would share a district, and Maine and Massachusetts would share a district, which, I mean, they were one state, Maine and Massachusetts, until 1820, the Missouri Compromise. But apart from that, all the other 13 states got their own district, and then there would be 3 circuit courts, the Eastern, which included New England and New York, the Middle, which included New Jersey, in the north, south to Virginia/Kentucky, and the southern, which included the Carolinas and Georgia. The Judiciary Act also stipulated that the Supreme Court would consist of 5 associate justices and 1 chief justice. In the early years after the act was passed, the Supreme Court only convened twice a year for 2 weeks at a time. So the Supreme Court met for a grand total of 4 weeks in the early days after the Judiciary Act of '89 was passed and signed into law. The justices actually spent most of their time, because obviously the Supreme Court's only in session for like a month out of the year, the justices spent most of their time riding the circuit, as it became known, or sitting as judges in the circuit courts that I mentioned a moment ago, which acted as courts of appeals do now. And they also, these circuit courts, served as national trial courts with authority over high-profile crimes and cases that had out-of-state or foreign plaintiffs, or those involving admiralty or maritime issues, legal issues that went on at sea, basically. Given the dynamics, the Supreme Court was not initially expected to do a whole lot. And in fact, by 1801, so it had been in existence for about 12 years by 1801, it had heard a grand total of only 87 cases in 12 years. Since 2005, for some perspective, the Supreme Court has heard an average of about 75 cases each year. Effectively, the Supreme Court is likely to hear about as many cases in a year as the Supreme Court heard in the first 12 years of its existence. I mean, a little less, but not all that far off. So the Supreme Court just wasn't doing a whole lot in the 1790s. When it came to qualifications for who was going to sit on these courts, legal training was actually considered to be almost ancillary to the job of being a judge, and many of the judges and justices in the late early 1800s had little to no legal training or experience. Rather than legal expertise, the character of the individual and his place in society were deemed to be the most important factors in determining whether or not he should be able to hold the position of a judge or a justice. And that is really due to the influence of the colonial period, because the judges, magistrates that sat on British courts very often did not have much, if any, legal training, and they were there because they were members of the elite class who had some kind of education and were deemed to be wise enough and of high enough character to have a position like this. Interestingly, judges and justices at this time in the 1790s were not considered to be strictly dispassionate legal umpires as they are in the modern world. It was not only common, but expected for judges and justices to politic, and their charges to grand juries often had a distinctly political character, to the point of being printed in newspapers as political messages, which is crazy to think about in the world that we inhabit now. Judges even went so far as to recommend how juries should rule in cases. During the trial of those accused in the Whiskey Rebellion, by way of example, Justice William Patterson, who sat on the Supreme Court with Marshall, explicitly instructed the jury to find the defendants guilty. He said, quote, "There is not, unhappily, the slightest possibility of doubt. The crime is proved," unquote. Can you imagine? Especially if you're a lawyer or any kind of legal professional, a paralegal, whatever, if you know something about the way that court trials work, you probably understand that this is a big, big, big no-no for judges nowadays. If a judge were to do this, my understanding is I've got, my sister's an attorney, my mother's an attorney, my stepdad was an attorney, my girlfriend's an attorney. From what I understand about how courtrooms work, this would be grounds for like a mistrial if a judge were to tell a jury how to rule nowadays. But that was pretty common practice back in the 1790s. All of this stuff, the lack of concern with legal background, legal education for potential judges, the politicking, the advisement on convictions, it's because that is the way that Americans had experienced the judicial system under Great Britain. And still, at this time in the 1790s, Americans continued to think of judges or justices of the Supreme Court in the way that they had during the colonial and post-revolutionary periods. So all this behavior didn't really seem all that weird or outlandish. A judge telling a jury how to rule, that was something that a lot of people in America at this time were used to. And it just continued as the judicial system evolved from the English one to a distinctly American one. This perception of the proper role of the judiciary, not as just legal umpires, is further exemplified by the fact that Chief Justices John Jay, who was the original Chief Justice of the Supreme Court, and Oliver Ellsworth, the second Chief Justice of the Supreme Court, both headed foreign missions to negotiate treaties with Britain and France, respectively. With the full endorsement of George Washington, he sent Jay to negotiate, of course, the Jay Treaty with Great Britain, and Oliver Ellsworth was sent to France by John Adams to help negotiate an end to the hostilities of the Quasi-War. That demonstrates the degree to which Americans thought of judges and justices as political figures, and how different it was in the 1790s from the way that we think of it today. However, obviously things did have to change, because what I'm talking about here so far does seem weird and out of character for the way that judges and justices in the American legal system now behave. So some changes did come to this whole system. The Federalists, always with an eye on legitimizing the power of the national government over the states and looking to unify the American people to a greater and greater extent under that government, sought to use the judiciary for both of these purposes, to establish the supremacy of the national government over the states and to unify Americans together as Americans rather than as Virginians, New Yorkers, Georgians, and so forth. In 1796, the Ware v. Hilton case provided one such opportunity. The Supreme Court ruled that the Supremacy Clause of the Constitution gave treaties of the United States government primacy or priority over state laws, and thus a law in Virginia was overturned in a debt collection case. There were a lot of cases that had to do with paying off the national debt at this point that had been one of the big political bones of contention in the 1790s with Hamilton's program and his push for assumption of all of the state debts by the national government and all of the states then paying all of those debts off. That was pretty controversial. Similarly, the Supreme Court ruled in Hilton v. United States, also in 1796, that the new federal government had a broad enough taxing power to overturn a Virginia case against a federal carriage tax, another case of state law challenging federal authority. There was, of course, pushback to this extension of federal authority, and that is probably best and most dramatically illustrated in the reaction to another court case, Chisholm v. Georgia. That decision came in 1793, a few years before these other two decisions I'd mentioned, and that was one in which the court decided that citizens of another state could sue the state of Georgia. So these citizens from, I don't know if it was from South Carolina, North Carolina, Virginia, wherever, but they sued the state of Georgia, and this was something that even some Federalists were shocked and dismayed by. And they thought that this was overreach. A lot of Federalists, and of course a lot of Republicans, thought it was overreach. And because of the severe reaction against this case, that is how you get the composition and ratification of the 11th Amendment to the Constitution, the first after the first 10, Bill of Rights. And that was adopted in 1798. It stipulates that, quote, "The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state," unquote. Naturally, there was pushback by Democratic Republicans at both the national and state levels to this attempt to extend the power of the judiciary and therefore the power of the federal government. Judges and justices seemed wholly undemocratic to many enthusiastically partisan Republicans, and they took numerous steps to try to reduce the influence of the judicial branch as an unelected branch of government that could subvert the will of the people in their view. These judges were not elected by anybody, and that seemed very undemocratic to the most ardent Republicans of the period, who were all about democracy and not letting elites or the upper classes have their way. I've already mentioned in a previous episode the successful impeachment of federal judge John Pickering of the District Court of New Hampshire in 1803. Apparently, he was kind of nuts, crazy, literally, and a drunk, like he was drinking while he was on the bench. So that was a pretty difficult one to object to, impeaching and getting rid of John Pickering. And there was also an unsuccessful impeachment attempt. I mean, he was successfully impeached, but he was not convicted and removed from office. Justice Samuel Chase was impeached in 1804, and I think the trial took place in early 1805, where he was handily not convicted because it was pretty political. Chase was saying things from the bench that Jefferson didn't appreciate, Democratic Republicans in general didn't appreciate, and Jefferson hinted to his allies in Congress, hey, y'all maybe might do something about this guy. Didn't come out and say impeach him, but that was pretty clearly implied. And so he was impeached on some pretty flimsy shit and therefore was not convicted. And that was ultimately a good thing because it did not establish this pattern that I think would have been quite destructive of judges being impeached just for issuing their opinions. If that sounds familiar to you right now, if that sounds like something you're hearing about in the news, it probably should. I hope that you can sort of, as you're hearing this, make the connection between why it is we want the judicial branch to be able to do its job and render rulings on legal findings, on cases, without fear of being thrown out of their positions. You know, you want men and women in the judiciary who are going to feel free to exercise their intellectual and moral imperatives in interpreting the law and not think that, oh, if I say the wrong thing, I'm going to be thrown out of my job. But there were other instances in this period in which opponents of judicial power attempted to use impeachment as a weapon against judges they considered abusive of their authority, apart from the two cases I just mentioned, probably the most famous of which was this Federalist judge, Alexander Addison, who was impeached in the state of Pennsylvania. He was removed from the Pennsylvania State Court of Common Pleas in 1803. So he was, Judge Addison, successfully impeached and removed, kind of purely for political reasons from what I've gathered. And again, not a thing that I think would have been a constructive pattern to establish. Because you want judges to be able to say something that is intellectually honest about the law and not worry about losing their job or ending up in jail because of it. I think that's generally something that most Americans today would agree on. Impeachment of judges was largely abandoned by the end of the Jefferson administration, though, because it often failed. And by 1807-08, the last couple years of Jefferson's presidency, a well-defined schism had occurred in the Republican Party because the Federalists had sort of gone bye-bye at that point. They weren't totally gone, although by the end of the War of 1812, they pretty much would be. There was this split that had emerged in the Republican Party, and it emerged even before 1807-08. You saw the green shoots of a schism emerging, probably like 1801-02. But the schism in the Republican Party was between the moderates who supported the role of a robust judiciary that applied American common law in its decisions and defended property rights without succumbing to the mob, as it were. And on the other hand, B, those populists who wanted to neuter the judiciary by constitutional amendment or even eliminate it altogether in the interest of greater democratic force in the American government. That is the split that is established by the end of Jefferson's presidency. You've got the Republicans who are cool with the judiciary and see it as having an important role in the federal government, in the state governments. And then you've got the portion of the Republican Party that is hostile to the judiciary because they see it as undemocratic and a tool of the Federalists and those who want a more powerful federal government, which they generally oppose. Okay, last major thing I'm going to discuss here is John Marshall and in particular, the importance of the Marbury versus Madison decision. As I hope you're sort of getting a feel for at this point, up to now. Yes, the judiciary exists. Yes, the judicial branch is woven into the Constitution. And it is sort of, at least, supposed to be one of three co-equal branches of government. But, as a number of historians I've read have pointed out, in the 1790s, through the Marbury-Madison decision in 1803, it's very clearly the legislative branch here, the executive branch here, and the judiciary, like, here. Okay? So in theory, yes, the judiciary is there, and it's supposed to be one of three co-equal branches of government, but in operation, in practical, day-to-day function of the federal government, the judicial branch was clearly inferior to the other branches of government up to this point. And Marshall's tenure as Chief Justice, which goes on for a long time, he's there for well over 30 years as Chief Justice, and the Marbury-Madison decision in particular is what establishes the court truly as a co-equal branch of government. Into this volatile situation where you've got Republicans and Federalists fighting against each other over what the role of the judiciary is going to be, steps John Marshall, who was appointed to be Chief Justice of the Supreme Court by John Adams shortly after Adams found out he was defeated in the election of 1800. Adams originally wanted to reappoint John Jay, but John Jay was kind of like, pass. No thanks. He'd already been Chief Justice, and the fact that he was so willing to pass on the job again is just one more indication of how the judiciary was not on the same level as the other two branches of government at this point. Marshall, for his part, was a staunch, if moderate, Federalist who had served under George Washington at Valley Forge, among various other deployments during the Revolutionary War, and had come to believe, both through his experience with the ineptitude of the national government under the Articles of Confederation, he, like many other soldiers, saw how dysfunctional the national government was under the Articles, and that stuck with him for a long time. So both because of that and because of Marshall's faith in George Washington as an unimpeachable character, he came to believe that the United States needed a strong national government, an energetic national government, and an authoritative national government that would bind the states and Americans individually together as one country. Marshall was forever touched by his experience with the deprivations that he and other soldiers had had to go through. He saw that as unqualified evidence for the fact that a weak central government was not going to work. On the other hand, Marshall had opposed the Alien and Sedition Acts because he thought they were inappropriate. He was not a hard party line guy. He said afterward that he would not have voted for them. But he had wanted Aaron Burr, rather than Thomas Jefferson, to become president in 1801. Coincidentally, Marshall was Jefferson's second cousin, I think like once removed or something. Marshall's grandfather was Jefferson's father's brother or something like that. I forget exactly what their relationship was, but they were kind of distantly related. And Marshall was one of the few Federalists from Virginia, which was a very heavily Republican state. He thought Jefferson was not a man of character. No disagreement from me, as you probably know by now. He thought Jefferson was too sympathetic to France, and he considered Jefferson a shirker because Jefferson had not served in the military during the Revolution. And like all other Virginians and a lot of people outside of Virginia, Marshall was well aware of Jefferson's leadership, or lack thereof, during Jefferson's tenure as governor of Virginia when the Revolution was going on. Remember, he had given up the government essentially without a shot, had Jefferson. Retreated, not stood up, and that was something that stuck with him for the rest of his political career. And a guy like Marshall, who'd suffered through Valley Forge and been a good soldier in many other instances, was someone that just didn't have a whole lot of respect for Jefferson because of that and because of other reasons I've already mentioned. On top of that, Marshall was apparently a really affable, gregarious guy. Kind of the opposite of Jefferson, who was a little more standoffish, didn't like to pal around with guys or be in groups. He was sort of a nerdy philosopher kind of guy, and Marshall was sort of a guy's guy who I guess was very athletic and liked to, mix it up with other guys, have drinks and all that kind of stuff. And, Jefferson was not that sort of dude. So there were a lot of reasons that Marshall and Jefferson just didn't see eye to eye, and they really didn't care for each other. The whole time, Marshall was Supreme Court Chief Justice and Jefferson was president, and even after that. Of course, their personal disdain for one another made Marshall, as Chief Justice of the Supreme Court, delivering the oath of office to Jefferson when he became president in 1801, pretty fucking awkward. There's a story that allegedly Marshall turned his back on Jefferson once the oath was delivered. I think that's apocryphal. I'm not sure that it actually happened. But the fact that it's even out there as a story just demonstrates the degree to which they really didn't get along. Marshall actually only reluctantly accepted a role in public service when he initially got involved. He ran for Congress, and I think it was 1796. If it wasn't 1796, it was 1798. He was loath to give up his apparently quite lucrative legal practice in Virginia. But Washington apparently really pushed Marshall to run for Congress because Washington was getting pretty nervous about the Republicans, and he wanted someone like Marshall in there as a counterweight to what Washington saw as nefarious Republican influence on the national government. There's even a story apparently about Marshall trying to bail out of Washington's place because he knew Washington was going to ask him to run for Congress. He tried to get on his horse, did Marshall, and sneak out of there, but Washington caught him at the stable and was like, "So you're going to run for Congress, right?" And Marshall acceded and did run for Congress and won a pretty close election. That's how he initially got involved as a public servant. So it's not too long after Marshall becomes an elected member of the House of Representatives that John Adams asks Marshall to be one of the three men that he, Adams, sends to France to try to work out the problems between the French and the United States in the midst of the whole kerfuffle over the Jay Treaty that had happened at the end of Washington's administration. And it is from this assignment that Marshall achieves his initial fame in the United States. He becomes one of the figures in the midst of the XYZ affair, and it's Marshall's accounts of the misbehavior, the humiliating conditions that the French diplomats put on the American ambassadors that gets circulated among all of the newspapers and representatives in Congress and so forth that brings to light what is known as the XYZ affair. So Marshall becomes kind of a hero as somebody who exposed what the French were doing, and that's how he becomes a national figure in the first place. Eventually, as you might remember, Adams taps Marshall to be his Secretary of State once he finally gets rid of Timothy Pickering. That is the position that Marshall is in when Adams asks Marshall to become Chief Justice of the United States. And Marshall's important not just for this one decision, Marbury-Madison. He's important because he helped change the culture of the court by convincing the associate justices to reach collective decisions on cases rather than issuing opinions individually, as had been the English tradition that the court followed prior to Marshall's appointment. He made the court more collegial. Like I said, he was a likable, affable guy and was able to charm a lot of people to get them to cooperate with him. And often, over many glasses of wine, he and his associate justices would reason together to reach a consensus of some kind, which he continued to do even after Republican appointments left him ideologically outnumbered on the court by about 1810. So he was able to get the associate justices to come together, work out the details of the case, and reach a consensus decision in many cases. And I guess there's kind of a funny story about how the justices tried to limit the amount of time they would spend drinking wine together when they were discussing decisions. And Marshall would say to one of the associate justices, "Hey, what's the weather like outside?" Because they at least pretended that they were only going to have wine together when it rained. If it was sunny outside, he would say, "Well, our jurisdiction covers a wide territory. It's probably raining somewhere. Let's have a drink." That was the kind of guy he was. He got a lot of folks who might have disagreed with him ideologically to sit down and reason and work things out with him. Between 1801 and 1805, Marshall wrote 209 of the 378 opinions issued by the Supreme Court, although none of them were as impactful as Marbury Madison in 1803. Marshall understood that he was operating in a political environment that made the judiciary's role tenuous, and consequently, he searched for ways to subtly preserve the branch's co-equal status by asserting its role where he could and by being accommodating to his Republican rivals when he had to be. He was, from what I've read, very smart politically. He had good political instincts in addition to good personal relationship instincts. It was Marshall, for instance, who convinced the justices to don simple black robes that judges in Virginia wore, rather than the ornate gowns or robes of scarlet or ermine that they had worn before Marshall was appointed to the court. They had these fancy academic robes, I guess, and Marshall was like, let's just wear the black robes. It looks simpler. And he knew that that would appeal to the unpretentious and enthusiastic about democracy Republicans on the other side. Apart from changing the dress code and the way that the justices would reach decisions together, Marshall also surrendered the criminal common law jurisdiction that so many Federalists had pushed for the courts to have by 1812. He recognized it was a political impossibility for the courts to retain this authority, the authority of criminal common law jurisdiction, which was something that a lot of Federalists in the 1790s were pushing for, and that giving up this whole idea voluntarily would be a meaningful olive branch to Republicans, which it was. They appreciated that. But it was in the Marbury case that Marshall gave the Supreme Court and the judiciary more generally its most important role. In the majority opinion that Marshall authored, he explained that although he believed the Jefferson administration was acting shamefully in not delivering Marbury his commission to be a justice of the peace in the District of Columbia, the court did not have the authority to issue a writ of mandamus to order Jefferson to deliver the commission. The whole case was based on this guy, Marbury, who was, I guess, a Maryland businessman and politico. He'd been given one of the midnight appointments by John Adams as a justice of the peace. That was one of the ones that Adams issued on his way out the door, although it was never actually delivered to him. And once the people in the Jefferson administration discovered that it wasn't delivered, they just kind of held on to it and didn't give it to him, though it had been signed and though a seal had been affixed to it. Marshall went through the whole decision and found that, yes, Marbury should have gotten his commission. That, yes, he should seek some legal remedy to get his commission delivered. That, yes, his rights had been violated because he did not get his commission. But Marshall said that it was not in the jurisdiction of the Supreme Court to make a decision like this and deliver a writ of mandamus to give Marbury his commission. Marshall declared that the portion of the Judiciary Act of 1789 that granted the Supreme Court the power to issue writs of mandamus was unconstitutional. Congress didn't have the authority to change the jurisdiction of the court as was laid out in Section 3 of the Constitution. So Marshall is saying that the Judiciary Act of 1789, at least a portion of it, gave authority to the Supreme Court that the Supreme Court should not have, according to Article 3 of the Constitution. And I want to read a portion of one of the books I mentioned, The Great Decision, because I think it gives a very good breakdown of what exactly this meant and why it was. So here it is. Marshall noted that the Judiciary Act of 1789, written in large part by framers of the Constitution, gave the Supreme Court the power to, quote, issue writs of mandamus to persons holding office under the authority of the United States, as a trial court, with no requirement of first seeking relief from a lower court. Marshall then considered the Constitution. As Marshall explained, the Constitution provides that, quote, "The Supreme Court shall have all original jurisdiction in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party. In all other cases, the Supreme Court shall have appellate jurisdiction." So basically, Marshall is saying that the jurisdiction the Judiciary Act of 1789 is trying to provide to the Supreme Court is not okay, according to what Article 3 of the Constitution says. The Judiciary Act of 1789 was trying to give the Supreme Court jurisdiction it should not have, in Marshall's opinion. And that's very important for a couple of reasons that have long-term impacts for how the judicial branch works. Number one, it's saying that the Constitution is the supreme law of the land, and that Congress can't make a law that conflicts with the Constitution. That if a law passed by Congress does not jive with the Constitution, it's the Constitution that prevails, and that law is void. Secondly, and most importantly, specifically for the judicial branch, by making this decision, Marshall is affirming the right, the power of the courts to determine what is or isn't okay according to the Constitution. That is judicial review. The power of the courts to interpret what the Constitution is saying. And this is the case that establishes that power as a precedent. The way that Marshall is doing it is noteworthy as well, because he is striking down a law passed by Congress. It's the first time that it had ever been done, and it wouldn't be done again until 1857 in the Dred Scott case. So it's a big deal in a lot of ways, this case. It's why it's so important. It's why I wanted to make sure that I discussed it in detail. Jefferson ultimately didn't challenge the decision in any meaningful way, particularly given that it prevented Marbury, who was a staunch Federalist, from getting his commission. The Marshall Court also declined to strike down congressional repeal of the Judiciary Act of 1801, which Congress had repealed. I discussed that in an earlier episode. And Jefferson and Republicans were really happy that the court didn't challenge their repeal of the Judiciary Act of 1801 because the 1801 Judiciary Act, had expanded the scope of the courts in a way that gave Federalists more power. Marshall recognized he didn't want to challenge their repeal of the law because it would be politically risky for the courts to do that at this time. So he let that go. That more or less made the Republicans happy. And because they were pretty happy with that decision, they were less willing to go after Marshall in the Supreme Court based on the Marbury decision. Coupled with other Supreme Court decisions during Marshall's tenure, like Fletcher v. Peck, United States v. Peters, and Martin v. Hunter's lessee, the Marbury decision solidified the standing of the judiciary as a co-equal branch of government, augmented federal authority relative to that of the states, and more firmly established the court's role as the branch of government charged with interpreting the Constitution. As Hamilton advocated in Federalist 78, quote, "The interpretation of laws is the proper and peculiar province of the courts. A constitution is, in fact, and must be regarded by the judges as a fundamental law," unquote. Madison appeared to endorse this as well for some time until his split with Hamilton, and that kind of changed things around. But this is monumental, right? When you think of the things that it does. Again, it establishes the judiciary as a co-equal branch of government, gives more power to the federal government by ensuring that federal laws and the Constitution supersede state laws, and it specifically grants the judiciary branch the power to interpret the Constitution, making this precedent the first example of that. The Supreme Court is striking down a portion of a law passed by Congress, and the fact that the executive and the legislative branches accepted that decision meant that they were willing to accept this as a principle in general going forward. So by avoiding a direct confrontation with the more powerful branches of the federal government, and by being patient and thoughtful in his actions, Marshall was able to gradually build up the credibility and power of the judiciary during his tenure. He outlasted his rivals in both parties, ultimately, and was perhaps the single most important jurist ever to sit on the federal bench. So that's everything. A little bit of a longer episode today. I hope that you, in listening to all of this, see why I felt the need to go through all of these things. I think to paint a really clear picture, it's important to provide the proper context and to go into this very important decision and Marshall's place on the bench in general. Thanks for watching as always. Again, please like and subscribe. Please spread the word. Also, if you would like to reach out to me with any comments or questions or suggestions, you can do so at howthehell.did-we-get-here-pod@gmail.com, or you can leave me a voicemail or a text message at area code 951-525-5536. Thanks very much as always. Take care, and I will see y'all next time.